My name is Adam Posick, and today's session is going to be on fiduciary roles by the numbers. We're going to look at ERISA 321 and 338 investment professionals and ERISA 316 plan administrators. Before we get into some of the specific fiduciary roles, it's really important as context to have an overview understanding of what fiduciary status means. Even though some of the specific sections of ERISA, like 321, 338, and 316, have taken on sort of marketing meaning in terms of promoting different types of services, if we look at what those statutes actually say, ERISA 321 is sort of the top-level garden variety fiduciary definition. And there are basically three components to that. So anyone who has or exercises discretion over plan administration, plan investments, or anyone who gives investment advice for a fee or other compensation. ERISA sections 316 and 338 go a little bit deeper, and those are specific types of fiduciaries. So again, 321 describes all fiduciaries. 316 and 338 talk about very specific types of fiduciaries. So 316 is the plan administrator, and ERISA section 338 talks about investment managers. And we'll discuss those in more detail on later slides. It's also important to understand that even though the correct determination might be fiduciary in nature, the provider performing certain functions might not be doing so as a fiduciary, and we can see some of those examples on the screen here. So, for example, application of the rules determining eligibility. Now, the fiduciaries are responsible to ensure that everyone who's eligible for the plan is given the opportunity to participate and so on and so forth. But if a third-party administrator, for example, is simply taking the rules that are written in the plan document and applying those to a set of demographic data that was provided by the plan sponsor, then that performance, that determination of eligibility would not necessarily be fiduciary in nature. Some of the other things that are on the screen, so processing claims, calculating benefits. So if the plan document spells out the rules of the road and a service provider is simply taking those rules and overlaying them on top of objective information, then that determination by simply applying a formula is not going to cause that service provider to be a fiduciary. Now, once those calculations are done and they're provided back to the plan sponsor to sign off on and specifically authorize a payment from the plan, that authorization and sort of putting the stamp of approval on everything would be a fiduciary function. So it's an important distinction. Sometimes it can be a little bit difficult to understand, but it is an important one nonetheless. Simply applying a formula to a set of data, not fiduciary in nature, but exercising discretion or formally approving the disbursement of money from a plan, that would be fiduciary in nature. First and foremost, a fiduciary's duty is going to be to the plan and to the participants, not the plan sponsor. That certainly can create some challenges if you have the president of the company who's acting as the trustee and a fiduciary. So as a fiduciary, as a trustee, the responsibility is to the participants, not to the company. But as owner of the company, it's kind of hard to switch hats and then be responsible to the company. So it can create some interesting challenges. I've got some excerpts from ERISA section 404A here on the screen with some parts highlighted. So basically the fiduciary has to act solely in the interest of participants and for their exclusive benefit. And then the second bullet point right here talks about the level of care that's required. So with care, skill, prudence, and diligence, that a prudent person familiar with such matters would use in the conduct of an enterprise of a like character. So it's not just a standard of care of someone who's trying hard to get it right. A person who's a fiduciary is expected under the law to act as a prudent expert would. And this is actually one of the highest standards of care anywhere in U.S. law. So certainly ERISA fiduciaries are held to an extremely high standard. Now, ERISA does provide for the delegation of authority and certain responsibilities. So there's not an expectation that everybody who's a fiduciary is going to be an expert in every possible way or every possible subsection of the various requirements. So it is certainly possible and certainly allowable for an ERISA fiduciary to bring in other experts to assist in fulfilling those duties. So you can see kind of working through the screen here, 402A1 provides that a plan must have one or more named fiduciaries who are jointly and severally responsible for the operation and administration of the plan. Now, jointly and severally, that's a really important term to highlight, because essentially what it means is that they're equally on the hook. for the responsibility and any resulting liability if they don't satisfy their obligations. So just to kind of boil that down, if there are two fiduciaries and they're each responsible to handle kind of half of the plan administration, and one of them gets it wrong, then they're not each 50% liable or one 100% liable and the other 0% liable. Joint and several liability or joint and several responsibility means that both of those individuals are equally on the hook to ensure the proper management and operation of the plan, and if it isn't proper, they're both 100% on the hook for any resulting penalties. So it becomes really, really important for an ERISA fiduciary when appointing other fiduciaries to ensure that they are expert in the area where they're supposed to be expert, because if that other fiduciary gets it wrong, the appointing person is also going to be on the hook for that mismanagement potentially. So again, important to understand this concept of joint and several liability among ERISA fiduciaries. Again, working our way down the screen, ERISA 402(b)(2) says that a plan has to have a procedure for allocation of responsibility. So it's not just on a wing and a prayer, hey, handshake, you're now responsible for XYZ part of the plan. The plan document has to say, here's how the trustee, here's how the plan administrator, here's how the fiduciaries apportion responsibility to other parties, and then so forth down the screen. So on the last slide, we talked about fiduciaries being on the hook jointly and severally, but let's take a look at some of the parties to whom a fiduciary may be on the hook. The Department of Labor is the federal agency that has jurisdiction over the enforcement of ERISA. And you can see on the screen some of the monetary results of DOL investigations and so forth. And these go back to 2014. Each year, the DOL publishes their monetary results on their website. But you can see that their total recoveries in fiscal year ended 14 were almost $600 million. They closed almost 4,000 civil investigations and just over 350 criminal investigations. So yes, it is possible as an ERISA fiduciary for certain infractions to cross the line into being criminal. Now these typically involve intentional theft of assets and things of that nature. Simply forgetting to send in employee deferrals until they were 5 days late is not going to really cross the line into criminal behavior. But I do like to illustrate that there are certain infractions that can be criminal. So an ERISA fiduciary is on the hook with the Department of Labor. If the DOL audits a plan and they find certain fiduciary mismanagement, even if unintentional, all of the plan's fiduciaries are potentially going to be on the hook to make those situations right. With the plaintiff's bar, over the last few years, plaintiffs' attorneys have certainly discovered the huge pot of money that exists in ERISA-covered 401k plans. There have been a number of excessive fee cases against large 401k plans, and more recently the same sorts of suits have been filed against large 403b plans. So if you are a fiduciary, then you're in it for the long haul. And in a lot of these cases, even if the plan and the fiduciaries ultimately prevail, they're still spending seven figures on the defense costs to protect themselves in these lawsuits. For a service provider or an individual who's not a fiduciary, they're going to be out early. Their attorneys are going to make the case, hey, this individual, this party is not a planned fiduciary, therefore they can't be liable for a fiduciary breach. And so they're going to be out at the beginning. So very important to understand which side of the line you or your service providers are on. And not to be left out of the fun, but the IRS also has some jurisdiction here, in that certain fiduciary breaches that lead to prohibited transactions are going to be subject to excise taxes under Code Section 4975. So these are just some of the situations, some of the parties to whom a fiduciary is going to be potentially on the hook to if they don't fulfill their obligations to prudently manage the plan on an ongoing basis. So we talked about the plaintiff's bar on the last slide, but just to give a little bit of additional color to that. And this is a study that goes back to 2010. I haven't seen an updated version of it since then, but it still makes the point. If we follow our way across, these are the percentages of cases by type and sort of what was the main thrust of what they were claiming. A question about a duty of loyalty, contributions not being handled properly, not properly adhering to plan documents. So these are kind of some of the different infractions that the plaintiff's bar was claiming in some of these cases. But you'll notice breach of fiduciary duty that claim occurred in 100% of the cases. So regardless of what else a plaintiff's attorney is suing for, they are claiming, at least according to this study, in 100% of the cases, that there was a breach of fiduciary duty. So again, going back to the previous concept of joint and several responsibility, joint and several liability, it's important for plan fiduciaries, particularly plan sponsors that are hiring other service providers to assist them in a fiduciary capacity. It's important to make sure that those people that you're hiring are true experts. They understand that their duty is to the participants, and they have the knowledge and the experience to be able to help in a prudent manner. Because if not, then potentially that plan sponsor is going to be on the hook for hiring a fiduciary that wasn't up to snuff, that didn't fully understand their responsibility. Now, one term that has sort of bubbled up just sort of in marketing conversations and whatnot is a co-fiduciary. And you really can't be a co-fiduciary. You either are one or you aren't one. Again, going back to this concept of joint and several liability, if you're a fiduciary, you're completely a fiduciary. You're not just part of a fiduciary. I liken it to being a parent. You're not a co-parent. Either you are a parent or you're not. The same thing is true with fiduciary status. Now, there can be co-fiduciary liability, and again, this kind of goes back into this notion of joint and several liability. And you can see what ERISA Section 404 or 405A says here on the screen. Basically, that a fiduciary is liable for the breaches of another fiduciary if he or she participates knowingly in or knowingly undertakes to conceal a bad act or a fiduciary breach by another party. So it's not just participating in, but if you know about it and you attempt to conceal the other bad acts, then you're going to be on the hook. If one fiduciary enables the bad act of another, then that first fiduciary is going to be responsible. Or if a fiduciary has knowledge of a breach by another fiduciary and doesn't do anything, doesn't take reasonable steps to remedy that breach. Now, remedying the breach or taking steps to remedy it might be removing that other fiduciary from a position of authority so that they can't do anything further, potentially bringing suit against that other fiduciary, or in some circumstances, even going to the Department of Labor to report that other fiduciary for the breach and not making it right. Those are just some examples of steps that one fiduciary might take in order to make a reasonable effort to remedy a breach by another fiduciary. And so these are obligations that ERISA says that exist on all fiduciaries, whether it's the plan sponsor, whether it's a plan service provider, no matter where you sit. If your role is a fiduciary, is fiduciary in nature with respect to a plan, these are some of the obligations that apply if you become aware of a breach that's taking place. Now, the slides that we've covered so far aren't there to scare anybody, although certainly a lot of the conversation about liability and co-fiduciary liability and that stuff can sound pretty frightening. We provide that context just to emphasize the importance of ensuring that as a plan fiduciary you are working with other service providers that bring the appropriate level of expertise to the table. If everyone is acting as an expert, if everyone is acting prudently and in the best interest of plan participants, then some of those liability concerns become a whole lot less because everybody's doing what they're supposed to be doing. Now, the retirement industry, it's always kind of struck me as a little bit funny how so many products and services are marketed by numbers. You've got the 401k plan, you've got the 403b plan. A few years back you had the 412i plan and the ever popular 419af6 plan. All of these pointing to sections of the Internal Revenue Code. Well, fiduciary services have followed suit. We've got 321 fiduciary services, 338 fiduciary services, 316 fiduciary services. And a lot of these terms are used in marketing materials and presentations and sales pitches and the like. But if you really think about it, the average plan sponsor, the average purchaser of those services, isn't going to know what ERISA Section 316 says. So some of these numbers that are used in marketing have sort of taken on a life of their own. These next few slides, we're going to go through some of these specific roles, looking at these sections of ERISA to identify what they mean. Now, another important point to keep in mind is that ERISA was passed in 1974. The 401k plan didn't come into existence until 1978. That's when Section 401k of the Internal Revenue Code was enacted. Even then, 401k plans were pooled. You had employees that would defer their money into one big pool, and the trustees were responsible to invest the entire pool. It wasn't until the mid to late 90s that you started to see individual participant direction, or employees choosing their own investments from a menu that was provided to them. And it was that time, or even a little bit later, that you started to see daily valuation, so that participants were not only choosing their own investments, but they had the ability to log into a website on a daily basis and change how their money was allocated. So I provide that historical context just to illustrate that a lot of the concepts that are in ERISA with respect to some of these fiduciary rules didn't contemplate the 401k plans that we have today. They contemplated pooled defined benefit plans. So very different world, and it can be a little bit challenging to shoehorn some of that perspective into our current environment of participant-directed daily valued 401k plans. The first item that we're going to talk about is the ERISA 321 fiduciary. Now, if you remember back to our first slide, I mentioned that ERISA 321 provides the garden variety definition of fiduciary. And it says anyone who has or exercises discretion over plan administration. And that's important because a lot of times when people are marketing 321 fiduciary services, they're marketing really investment services, not administrative services. But truly under ERISA 321, anyone who has discretion over the administration of the plan is also going to be a fiduciary. But since what we're talking about in this session is the way some of these numbers and these statutory sections are used for marketing, ERISA 321 or an ERISA 321 fiduciary typically is someone who is an investment advisor and is marketing their services along those lines. And it's typically they are providing investment advice for a fee. So what does the typical ERISA 321 arrangement look like? Now we could spend a lot of time dissecting this, but sort of the gist of it is that a 321 investment advisor is going to provide analysis, advice, and recommendations to the plan sponsor. But the 321 doesn't have any authority to implement those decisions on their own. The sponsor still has the decision-making authority. So the 321 comes in and says, plan sponsor, I think you need to put in a balance fund into your plan. These are the 5 different balance funds that I looked at, and I recommend that you go with balance fund A. The plan sponsor has the option to say, okay, advisor, I want to go with your recommendation. Or they can say, you know what, I've done some research on my own, and for XYZ reasons, I'd rather go with balanced fund C. So the plan sponsor still has the ability to override the investment advisor. So while the advisor is a fiduciary and is therefore responsible to do their job in a prudent manner and to only make recommendations to the plan sponsor that are in the best interest of the plan participants, that 321 advisor is not on the hook for the decision that the sponsor ultimately makes. The sponsor is on the hook because they're the ones that are exercising authority over the investment of plan assets. So the advisor is giving investment advice for a fee, so they're a fiduciary in that respect, but the plan sponsor is exercising discretion with respect to the investment of plan assets, so the plan sponsor continues to be a fiduciary in that respect. So really, in this sort of an arrangement, both the advisor and the plan sponsor are going to be fiduciaries under Section 321 of ERISA. I kind of think of the 321 as an investment GPS. So if you're in your car and you're driving down the road and the GPS says you need to take a right up ahead, but you say, you know, I would rather take a different route because it's more scenic, or I happen to know there's construction up ahead or whatever, you still have the choice to take a different route. And what's going to happen? The GPS is going to recalculate to now do the rest of its thing based on the decision you made. That's really what a 321 investment advisor is like. They're going to make a recommendation, but the plan sponsor still has the ability to make a different decision, and then the 321 investment advisor is going to recalculate and give future advice based on the decision that the plan sponsor made. Now, the ERISA 338 investment manager is more akin to the investment chauffeur. So if you have a chauffeur-driven car, you're typically not going to be sitting in the back seat looking over the chauffeur's shoulder and second-guessing the decisions that he or she makes in terms of which way they get you from point A to point B. You're going to get in the car and you're going to tell the chauffeur, this is where I want to go, and you're going to sit back and you're going to let that chauffeur make all of the decisions to get you to your destination. The same is true in the way that an ERISA 338 investment manager handles plan assets. So in that circumstance, the plan sponsor is hiring the 338 to take on full scope responsibility for management of the plan assets and the associated liability. So it's not saying, investment manager, bring me 5 options for balanced funds and I'll pick the ones that I like the best. It's basically saying, 338 investment manager, we've got this pool of assets. I am entrusting you to select the best investment options to provide to the participants, and you make the decision. Don't bring it to me for a right of first refusal. You're the expert. You do the research. You make the decision. You implement it. That's kind of the most concise way I think that I can explain what an ERISA 338 investment manager is. Now, it's important to note the second bullet point here, and that's that the plan sponsor still has an obligation to prudently hire the 338, to make sure that the 338 candidate has the appropriate expertise, has the appropriate experience, has worked with ERISA plans before. It's a very different world to choose investments for an ERISA plan as opposed to choosing investments for a high net worth individual. So is the investment manager well experienced, well acquainted with the rules that ERISA applies and the responsibilities that are applied to an ERISA fiduciary? And it's not just the selection, it's the prudent ongoing monitoring of that 338 investment manager as well. So it's not over when a plan sponsor hires a 338 to just kind of sit back, relax, and enjoy it and not ever worry about it again. Again, similar to the investment chauffeur analogy, it would be imprudent for you, if you had a chauffeur, to sit back and ignore the fact that your chauffeur last weekend was charged with driving under the influence and got in a car accident. It wouldn't be very smart to then entrust your life or the lives of your family or your children to this individual to drive them around when they've demonstrated that they don't act responsibly. Kind of an extreme example, but similar principle applies again in the world of a 338 investment manager. Once you hire that manager, the plan sponsor still has an obligation to monitor that person to ensure that they remain qualified to fulfill their duties on an ongoing basis. Now, one arrangement that is used sometimes is sort of a combination 321-338 arrangement. And in that situation, there is a 338 investment manager that is responsible for building and maintaining risk-based portfolios. So maybe a 401k plan has a menu of 20 mutual funds that the employees can choose from, and then maybe 3 to 5 risk-based portfolios. So a conservative, a moderately conservative, a moderate, a moderately aggressive, and an aggressive portfolio. And so there's a 338 investment manager who builds those models and reallocates as they deem appropriate. But then you still have this menu of 20 funds that's going to be offered to the participants. In that circumstance, the plan sponsor is typically working with a 321 advisor on the 20 mutual funds on that menu. So the plan sponsor is still a full-blown fiduciary involved in that decision-making process. But then with respect to the models, the risk-based portfolios, the role of the plan sponsor in that circumstance is going to be to monitor the ERISA 338 investment manager to ensure that they are doing their job with respect to those model portfolios on an ongoing basis. So we've talked about the 321 and the 338 fiduciaries, which are typically investment roles. So what about an ERISA 316 plan administrator? Very important role, has a lot of responsibility, so surely we should be able to look at the tax code and ERISA and get some guidance on what the 316 plan administrator does. And actually, if you look at those two bodies of law, there's not a whole lot of detail there. They do provide some degree of specificity in terms of some of the responsibilities. But really, it's very broad-based. The ERISA 316 plan administrator is responsible for the proper administration of the plan. Pretty much just what the name says. And proper administration of the plan is very, very broad in nature. So while you would think such a broad, important role would be described in detail in the law, it really isn't. But both the code and ERISA do give us some guidance, but we really turn to the plan document for additional detail on what the plan administrator is expected to do. So on this slide, we see some of the common duties that are assigned to the plan administrator. So the top one of the most critical roles, is that the plan administrator has discretion to interpret plan provisions and determine all questions regarding administration. Very broad. Where this comes into play frequently, or most typically, is a situation where there might be an ambiguous plan provision or there are some ambiguous facts. And somebody has to be the tiebreaker to decide, okay, it's not quite clear how we handle a given situation. It's not quite clear if, John Doe participant is eligible for the plan. Somebody needs to be the tiebreaker. Somebody needs to resolve that ambiguity and make a decision. That is going to fall on the plan administrator to make that sort of a decision. So some of the other things that are common in sort of the day-to-day operation of a plan: filing the 5500, processing mandatory distributions, furnishing notices, filing the 1099-Rs each year for those that took distributions, withholding taxes, hiring actuaries. I won't read all of these to you. But one of the reasons that we want to talk about some of these specific duties is that there are a number of service providers that are marketing themselves as an outsourced ERISA 316 plan administrator alternative. So they're basically saying, plan sponsor, rather than you being the plan administrator and having ultimate responsibility for all of these things, you can hire us to be your ERISA 316 plan administrator, and we'll take those roles on as a fiduciary, so you no longer have that responsibility. That sounds really good, especially to maybe a small business owner that's busy, has a lot of responsibilities, and doesn't really feel like they have time to be responsible for maintaining the plan and making a lot of complex legal decisions. But there are a couple of reasons why that isn't necessarily going to be true on a cut and dried basis. First, just like we talked about on a slide or two ago with respect to a 338 investment manager, a plan sponsor has a responsibility to prudently hire their 316 plan administrator and to prudently monitor them on an ongoing basis to ensure that they're doing their job. So simply outsourcing the role of 316 plan administrator doesn't get the plan sponsor off the hook. Another reason why it's not necessarily cut and dried that this is going to be a value-added role to hire somebody in that respect is that a lot of these functions are actually already being provided by other service providers on a non-fiduciary basis. So for example, furnishing notices. Typically, you're going to have either a TPA or a record keeper who is preparing your SPD, your fee disclosure notices, your blackout notices. Now, they might not be actually sending them to all of the individual employees, but they're preparing them in a ready-to-send format. And if you've got a workforce where everybody has an email account and accesses email as part of their daily jobs, a lot of these notices can be supplied via email. So is there a real value add to pay an outside service provider an additional fee to do all of these things, to simply hit send on an email to a bunch of employees when you already have a record keeper or a TPA that's preparing those notices for you? One of the other obligations that ERISA imposes on plan fiduciaries is to ensure that any fees paid for plan services are not duplicative. And basically what that means is if you're paying one service provider to provide a service, you shouldn't be paying another service provider to provide the exact same service. That's a duplicative fee. So in this circumstance, if you already have a TPA and a record keeper providing a lot of these services and the only thing they're not doing is clicking send, is there a real value there from a dollars and cents standpoint to paying an outsourced 316 to basically just click send on distributing those notices? Filing Forms 1099 and withholding taxes on plan distributions. Again, that's a service that's usually provided by most daily record keepers in the industry, either the record keeper or the custodian. Just as part of processing a distribution, they're going to withhold taxes and they're going to file a Form 5500. So if you're already paying a record keeper to provide that service, are you then violating that prohibition in ERISA of paying duplicative fees by paying an outsourced 316 administrator to basically do the same thing or to just look over their shoulder to make sure they're doing their job? I mean, you already have a contract or a service agreement with your record keeper to perform those functions, so do you really need to hire a 316 administrator to enforce that contract? And if you do feel the need to do that, isn't that then not a service or something that you're doing in the best interest of the plan sponsor rather than the best interest of the participants. So even though a lot of the sales pitches and the marketing material around outsourced 316 services can sound really, really good, it's important to dissect them and really get into the detail to find out whether the services being offered really are adding additional value that you're not getting from existing service providers. Again, another one of the really popular services that's promoted is filing the Form 5500. Well, typically the TPA or the record keeper is going to prepare the 5500 on a signature-ready basis. So when it gets to filing the form, it's really just a matter of logging into the website, applying electronic signing credentials, and clicking Submit so that that form is electronically submitted to the Department of Labor. It's a process that really takes a grand total of about 5 minutes. So again, getting into this whole duplicative fee and determining whether there's real value there, is it worth paying an outsourced 316 administrator some percentage of plan assets on an annual basis to perform a task for you that really only takes 5 minutes? Again, not saying the answer is always yes or the answer is always no, but it's incumbent upon a plan sponsor, as a plan fiduciary in their own right, to look at these marketing pitches, look at the costs involved, and determine, is there a true value being provided to my plan participants from this outsourced 316 that I'm not already getting from my TPA or my record keeper. Now, if there is a situation where a plan decides to move forward with engaging a 316 administrator, or really a 321 or 338 investment professional as well, we go back to the fact that ERISA says that plans have to have a procedure for the delegation of responsibility. So if a plan sponsor is hiring one of these outside fiduciaries to assist them, we want to make sure that it's done in a way that complies with the plan document's delegation provisions. Otherwise, you could be spending money engaging the outside service providers, but not gaining all of the fiduciary protection that was anticipated. And that concludes our session on fiduciary roles by the numbers. Again, a lot of interesting sales pitches and marketing materials floating around out there in the industry. If you have any interesting discussion points or questions, please feel free to post those out to the discussion board.